Moving on to Part 4 of the bill, the fourth set of amendments perform essential legal housekeeping by validating the collection of various fees and charges charged by BCA, the Housing Development Board HDB, the National Parks Board MParks, and the URA. These include fees for existing operational costs, including the expedited inspection of buildings and the processing of temporary occupation permits (TOP) by BCA, NParks animal permits and species certifications, administrative fees charged by HDB, and recovery of expenses by HDB and URA for the immobilization, towage, and detention or storage of illegally parked vehicles. These fees and charges are essential to recover operational costs incurred by our agencies in providing services to the public. When originally introduced, these fees and charges were regarded as administrative charges for specific services or enforcement activities. However, following a comprehensive internal review, MND was advised that the fees and charges should have been prescribed in legislation. Therefore, clauses 9 to 12 validate fees and charges collected by our statutory boards, namely BCA, HDB, NParks, and URA, in the ordinary course of their operations. The necessary subsidiary legislation to prescribe the fees has either been made or will be made when this bill is enacted to provide the agencies with the relevant powers and clear legal basis for the continued collection of these fees. Clause 13 provides that the validation of the fees and charges made by clauses 9 to 12 do not affect any decision or judgment of the court given and any court proceedings commenced before the first reading of the bill in relation to the liability of any person to pay any of those fees and charges.
Part 4 asks this House to declare that the sums collected over a period of years by 4 agencies under the MND, namely the HDB, the NParks, the URA, and the Commissioner of Building Control, were always validly collected. When a statutory body has collected fees without the clear rulemaking authority to do so, the responsible course is to come to Parliament, put the position right, and ensure that the underlying functions continue on a sound legal footing. That said, Mr. Speaker, I think this House should take a moment of genuine interest in how we came to need Part 4 at all. These are not minor agencies charging obscure fees. 3 of them are statutory boards with long histories and well-resourced legal and policy functions behind them. The list of affected collections includes some of the most routine transactions a citizen in Singapore will have with the state: paying to expedite a TOP application, paying to register as a renovation contractor, paying a release fee after a vehicle has been clamped in the car park at the foot of one's block. For each of these, fees were being levied and collected over a period that the bill itself implies ran for years, on a legal basis that the government now concedes was inadequate. It is a significant thing for this to have happened across 4 agencies under 4 different parent acts and to have gone undetected for as long as it did. I would therefore like to ask the Minister a few questions because this House and the public deserve clarity. First, what is the aggregate quantum of the sums being validated under Part 4? How much money in total was collected under each of the 4 validating clauses and over what period? Moreover, how many Singaporeans have been affected by these collections? This is information this House should have before it is asked to put the matter permanently to rest. Second, on what legal basis did each of these agencies think they had the authority to impose these fees and charges in the first place? Every one of these validated categories was presumably charged pursuant to something: a rule, a subsidiary instrument, an administrative direction, or an internal policy. It would assist this House and bolster public confidence in the bill to understand what the legal basis was in each case and why it was thought at the time to be sufficient. These are questions about how the relevant agencies arrive at the view of their own powers. Third, how and when did the government come to realize that there was a problem? Fourth, what has the government done to satisfy itself that this problem is confined to 4 agencies and the categories listed in Part 4? A defect of this kind arising across 4 agencies under 4 different parent acts is not the sort of thing one expects to find in isolation. Are there something specific to the internal processes of these agencies that led to all 4 of them to independently arrive on a mistaken view of their rule-making authority? Or is there a possibility that the rule-making frameworks of our statutory bodies have a common weakness, which has now been exposed in these 4 cases, but may still be present in others? Fifth, has a cross-government review been commissioned in response to the discovery that led to Part 4? If so, who conducted it, what was its scope, and over what time frame? Are there other agencies, other fee regimes, or other categories of collection which the government has reason to believe may sit on similar uncertain legal foundations? Should this House expect further validating legislation in future sessions? If no such review has been undertaken, I would be interested to know why not. Sir, before we sign off on a retrospective validation covering years of collections under 4 separate statutes, I believe it is reasonable for the House to be informed about how and what else the government knows about the matter and what it is doing about it.
My concern is Part 4, the retroactive validation of past fee collections. Parliament sometimes has to correct administrative mistakes when an agency has been collecting fees without proper legal basis and foundation, and that gap is discovered. This House may need to regularize that position. This is unremarkable in itself. What is not unremarkable is the full scope of what Parliament is being asked to do. We are not simply being asked to validate past collections, we are also being asked to simultaneously extinguish citizens' rights to challenge those collections in court permanently. For anyone who had not commenced proceedings before the 7th of April 2026, the date of the first reading of this bill, this is not mere legal housekeeping. It is a significant step, and Parliament deserves the information to assess whether it is a justified one. We have not been given that information. In 2023, when this House debated the Constitution of the Republic of Singapore, bracket Amendment number 3, close bracket bill, a bill to enable President Tharman to hold international appointments in his private capacity, with its operative provisions backdated to the date of his inauguration. Then Deputy Prime Minister Lawrence Wong stated that backdating upsets expectations and prejudices individuals who rely on the existing law. He went on to argue that the backdating in that bill was acceptable because no one was actually prejudiced. That is one possible test for when retrospective legislation may be appropriate and a reasonable one. And it is precisely a test that Parliament cannot apply today because the government has not told us who was affected by these collections, by how much, or for how long. We are being asked to bar citizens from bringing claims without knowing whether those claims could have had merit. There is a second point the government needs to address. In the Goods and Services Tax Amendment Bill 2024, which addressed wrongly charged GST on government fees, the government drew a principled line. The 18 fees it acknowledged as genuinely wrongly charged, collected against its own policy intent, were refunded. Validation was reserved for a separate category. Fees the government maintained were correctly charged in substance, where the legal basis was uncertain due to inconsistent agency interpretation. Refund for what was wrong in substance, validate for what was ambiguous in law. This House approved that approach, and now consider where the agencies referred to in this bill sit on that spectrum. They did not merely charge fees on uncertain legal ground. They collected fees and, in HDB's case, made deductions from acquisition compensation without proper statutory authority. By the government's own logic in 2024, that is closer to the category that warrants restitution. Instead, Parliament is being asked to validate without refund and without any account of what was taken. Mr. Speaker, I am not asserting that large numbers of people suffered serious harm. I do not know. Neither does this House, because the government has not said. For each of the 4 agencies in Part 4, BCA, HDB, NParks, and URA, Parliament has not been given the duration of the lapse, the total amounts collected or deducted without authority, or any account of how many individuals were affected and to what extent. We are being asked to permanently bar legal proceedings without knowing the claims we are extinguishing. The HDB compulsory acquisition deductions are where this matters most. When HDB acquires a resident's flat, the resident is owed compensation as of right. If HDB was deducting its own administrative and legal costs from that compensation without statutory authority, then affected residents receive less than what the law entitled them to. Clause 18 prospectively authorizes such deductions going forward. That is Parliament's prerogative. But Part 4 simultaneously declares that past deductions were always lawful and closes the door on any legal challenge. Those who had already commenced proceedings before 7 April retain their rights, but everyone else is permanently shut out from that date, an arbitrary line drawn at the moment of first reading. I would add only this. If the deductions were trivial and affected very few people, the government can say so. The information exists. If the answer is reassuring, disclosure costs nothing. Its absence is harder to explain. I will not dwell on this, but it warrants a brief observation. 4 statutory boards under one ministry have simultaneously been found to have operated outside of their statutory remit. The bill regularizes the legal position. It does not explain how this came about across all 4 agencies at once, and it puts no mechanism in place to prevent a recurrence.
The third theme of questions surround the validation of fees collected by MND's statutory boards, which Mr. David Ho, Ms. Valerie Lee, Mr. Fadli Fauzi, Mr. Andre Loh, and Ms. Hazlina Abdul Halim raised. Now, the fees and charges in question were introduced over the years by various statutory boards for the provision of specific services to support residents' and industry's needs. The policy intent is clear and consistent with the cost recovery principles, but the fees were not formally prescribed in subsidiary legislation or the Parent Act at the time of implementation, as they were first regarded as administrative charges. Upon a 2025 review conducted by MND in consultation with the Attorney General's Chambers, AGC, MND was advised that it is better for these identified fees to be provided for in legislation. I wish to assure Mr. David Ho that the fees were appropriate and charged in good faith for services that were duly provided based on the principles of cost recovery. We also disagree with how Mr. Andre Loh and Mr. Fadli Fauzi has characterized the issue. MND has chosen to bring this issue to Parliament as we are open and transparent about the matter. The fees charged were appropriate, not wrongly collected, and we are validating to ensure that this is moving forward aligned with legislation. Mr. Andre Loh also mentioned that 18 fees were acknowledged as genuinely wrongly charged, collected against policy intent, and were subsequently refunded as part of the Goods and Services Tax Amendment Bill in 2024. However, in those cases, only the GST was refunded and not the actual fee itself, as they were collected in line with policy intent. In the specific case of compulsory acquisition by the HDB, GST was not charged as part of the fees, and the fees were also collected in line with policy intent. To Mr. Mohaimin's point on compulsory acquisition of HDB flats, compulsory acquisition cases are assessed on a case-by-case basis. And some cases are not just due to mortgage arrears, but are due to the violation of the HDB lease, such as renting out the entire flat during the minimum occupation period. On Ms. Valerie Lee and Ms. Hazlina Abdul Halim's queries, the fees are validated up to the date on which the fees are regularized and not 7th of April 2026. The cutoff date of 7 April 2026 is the date of the first reading of the bill. If the bill is passed, legal proceedings with respect of the collection of the payment of the fee or payment of the fees will be prevented from being instituted between the first reading and the date which the bill comes into force. This approach aligns to that for validations under previous bills, such as the Transport Sector Miscellaneous Amendment Bill. None of the validated fees were previously subject to legal challenge or adverse judicial comment. Moving forward, the agencies will assess if new fees or charges being introduced are related to the carrying out of statutory or regulatory functions and properly prescribe them in legislation if needed.
I think to begin with, I would like to frame clearly my concern with the bill. The effect of the bill is to now and forever extinguish the ability of those affected to claim any sort of financial restitution from the government, should it need be. Now, against this, we also have no idea about the size of the people who are affected. We also do not know the quantum affected. Are we talking about hundreds of thousands or hundreds of millions of dollars? So I hope the ministry can understand why there is this deep concern with me, especially since these are not, as I said before, these are not obscure transactions, but routine transactions which affect a huge number of people, a huge number of citizens of Singapore. And again, these are things like paying to expedite a TOP application, paying to register a renovation contractor. So I hope the ministry understands why it is, number one, important to get a sense of the numbers and the number of people, the numbers both in the sense of the total amounts that need to be claimed and the total amount of people affected. So I would like to reiterate the questions that I've asked. How much money in total was collected over under each of the four validating clauses, and over what period? How many Singaporeans have been affected by these collections? How many are we talking about? And I think it is important to know this information before we decide on this matter. The other thing that sort of makes me apprehensive is that on what legal basis did each of the agencies think that they had authority to impose these fees and charges? Because if I'm not wrong, the SPS said that it was classified under administrative fees. But what was the legal basis of them enabling them or allowing them to understand that they were allowed to charge these administrative fees? So again, I reiterate my second question. What legal basis did each of these agencies think that they had authority to impose these fees or charges in the first place? And of course, lastly, I think that it would be good for this House to reflect on why is it this happened. So I would also like to reiterate my last question on whether a cross-government review has been commissioned in response to the discovery. Because if it has happened for such a routine manner for over a long period of time, one can easily suspect that it may reoccur in other areas so that we can nip this problem in the bud early. Thank you.
SPS, Dr. Syed Harun.
Mr. Speaker, I thank the member for the clarification. And I think, first of all, it's important that we frame this bill amendment appropriately. The member frames it as having those affected, whereby it seems to suggest that there was a mistake made in the past, and therefore we're trying to correct it. And something that we've done in the past seemed to be egregious in that sense. But the spirit of this bill is really about making sure that we move forward with the legislative backing and mandate for our agencies. Previously, these charges, everyday charges with regards to allowing the four agencies to fulfill their statutory functions, were regarded as administrative charges. And services were indeed duly provided by the agencies. And tomorrow, services will still be provided for by the agencies. And in the course of providing these services, they had expended additional resources to deliver the services to the end user, manpower costs, administrative costs, system costs, with a view towards delivering services for the public. And on top of that, these fees were charged on the basis of cost recovery for the provision of such services. And as I've mentioned earlier in my speech, opening as well as the roundup speech, that the review was conducted by the ministry in 2025 in consultation with AGC, and it was advised that it is better for fees charged, it is better for the fees charged for carrying statutory and regulatory functions to be provided for in legislation, which is what we're doing today. So the framing of what Mr. Fadli is saying, that it is something that we are trying to claim back or claw back, it's not the right framing for which we are actually moving this bill forward. And essentially, it seeks to validate past collections of the same identified fees, which then further ensures that the fees are then subsequently legislated. The agencies are given the legislative backing to further promulgate these fees, and going forward, the fees will be regularized through subsidiary legislation under the relevant parent acts. Thank you.
Mr. Fadli Fauzi.
Thank you, Minister, thank you, SPS, for the clarification. I just would like to make it clear, I have no problems going forward about, regularizing such provisions. My concern is that we have no idea about the actual numbers that are being involved. And we are asked to extinguish the rights of these people to claim any monies. So would the Minister agree with me that the numbers are important, especially when assessing the risk of any oversight that has occurred with regard to the regulation of this bill? Thank you.
SPS.
I'd like to reiterate back again to the member that the nature of the fees that were charged previously was really on account of the service that was rendered by the 4 agencies. So the fees were openly prescribed to the extent where the services were required by Singaporeans as well as consumers. And therefore, to that end, the services were indeed duly provided for by the agencies. And on top of that, it was on the basis of cost recovery. I hope that reassures the member that whatever fees that were rendered were indeed transacted appropriately through the different agencies in accordance with their desire to make sure that the services were rendered for the public good as well as that of industry.
Ms. William.
Thank you, Speaker. I have one clarification for the Senior Parliamentary Secretary, and that's on the necessity for the retrospective legislation. Because if I heard him correctly in his opening speech, he said that there was a comprehensive internal review after which MND was advised that the fees and charges should have been prescribed in the legislation, should have been prescribed. But in his roundup, he appears to be shifting to say that, MND was advised that it's better to do it. So which is it?
SPS, Dr. Syed Harun.
It should have been prescribed, and therefore it was better that it would have been in legislation. Of course, which is...
Mr. William, if you would like to respond.
Yeah, sorry, sir, I should have stood up. Yeah, so on that clarification, then we are given to understand that the collections were actually not legally authorized.
SPS, Dr. Syed Harun.
The fees which were previously considered as administrative charges, have been advised to MND to ensure moving forward requires legislative backing to continue, because it is in the service of the statutory functions of the 4 agencies that are part of this amendment.
Mr. Andre Loh.
Thank you, Speaker. My questions to the SPS are in 3 parts. The first is a bit of a repetition of what my colleague Mr. Fauzi previously asked, but I don't believe his clarifications have been adequately addressed. It's simply about the numbers. Are numbers going to be forthcoming? Are they available? I would really appreciate a straight answer. Second, on the nature of the fees collected, I think my colleague Ms. Lim has also alluded to this. You mentioned earlier that fees and charges should have been prescribed in legislation, should have been being the operating terms. Now you are using a number of different terms: duly, appropriate, not wrongly collected, good faith. I think the simple question is, were the fees illegally collected? And I think on a reading of the fact that this bill is before us today, that we are regularizing the position prospectively, it goes to follow logically that previously it was not legal. So perhaps if the SPS could clarify. And finally, it's a very simple question. Will there be refunds? If there are not going to be any refunds, why no refunds?
Minister Chee.
Thank you, Mr. Speaker. Mr. Speaker, I think my colleague, SPS Syed Harun, has explained several times that the fees were previously considered as administrative fees. And he also explained why services were provided and these fees were collected on a cost recovery basis, which is the correct principle. So if the Workers' Party agrees that that is the correct approach, where we provide service, we should recover the costs, which will otherwise have to be funded by taxpayers if we don't do that, then there's really no refund to talk about, because this is not a wrong collection. So I think that's the first point we got to be clear. The second point is, we did this review ourselves together with AGC. It wasn't due to a complaint or a question posed by a member of parliament. We initiated this review and we decided that to be upfront, to be open, to be transparent, we want to bring it to the House and do it properly. Going forward, we want to make sure that we put it into legislation so that there's clarity. And for those fees that were collected in the past, and as I've explained, not wrongly collected, they were appropriate and they were correctly collected. We want to make sure that we validate and we do this through this bill. So I hope we understand what this debate is about and what it is not about. Thank you, sir.
Mr. Pritam Singh.
Minister, do you have the number of people affected and the quantum of monies we're talking about? Does the government have that information, and is it prepared to share that information in Parliament before we vote on the bill?
SPS, Dr. Syed Harun.
I beg your indulgence, Mr. Speaker. Mr. Speaker, I don't have the full number of the extent of the agent of the collective amount for as asked by Mr. Pritam Singh, but I can give you some indication in terms of what are the current numbers that we are looking at for specific agencies. In terms of the fees charged by Housing Development Board, the fees range from $3.27 for the renewal of a policy under the HDB Fire Insurance Scheme for owners who default in renewing the policy to $545 for an application for HDB's consent to sell a commercial property not under the lodgement scheme. We have other administrative fees which are also levied, but in total, specific to HDB, as an example, the total annual amount collected give me a minute just to make sure my numbers are right.
SPS, Dr. Syed Harun, if you need more time to
Yes.
gather the numbers, because we've been, oh, sorry, Minister Chee.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to explain to Mr. Singh and to the honourable members of the Workers' Party that it's not that we do not want to give you a number, it's that I hope you understand these fees were collected for over a long period of time. If I'm not wrong, I think since independence, when we first started. So we may not have the full, accurate record of all the amounts collected that we are able to share with you precisely. And that's why I think my colleague, SPS Syed Harun, was struggling a little bit to look for the exact information. But let me put it this way. If we agree that that amount that was collected is not incorrect, inappropriate, and wrongly collected, but it is because it was regarded as an administrative fee that was charged, then I think whatever the amount is, and we will certainly try our very best to see whether we can arrive at that number accurately, but whatever the amount is, I think it's something which we are trying to do what is right going forward, validating the past collections, and going forward, putting it into legislation. So I do seek Mr. Singh's understanding that we are dealing with a situation which goes back decades, and it's not the last 3 years or the last 5 years that we are able to obtain the information easily and accurately. Thank you, sir.
Mr. Singh.
Thank you, Mr. Speaker. I hear what the Minister has said. I'm also sure Minister has understood where the Workers' Party MPs are coming from. And I also would like to add that as the opposition, we come to this House to scrutinize bills. And it is our duty to ask those questions. Hence, those questions were asked not once, but they were asked repeatedly, I believe. They were not answered. So hence, we had to put that question out, even though I accept what the Minister is saying in terms of how far back it goes. Like in the explanatory statement to the bill, we didn't know that these charges went back to independence. I mean, so this is where we have to ask those questions, or some of them, I beg your pardon. But I note Minister's points, and I hope the SPS and the Minister has also understood the arguments that have been mounted by the Workers' Party MPs.
Minister Chee.
Thank you, Mr. Speaker. I thank Mr. Singh for his comments and his understanding of the difficulty that my colleagues in MND have in trying to put the data together. I also understand, certainly, where the Workers' Party is coming from. And I think it's correct that we be clear what we are putting before the House, and that's why we took effort to explain what this issue is, what is the objective, what are the steps that we are taking in an open and transparent way. And I think that's something that will be helpful for people to understand. So if we are able to come up with the information subsequently to the best of our ability, I think we will certainly be happy to share this with Mr. Singh and with the House. But for today, I do seek the support of members from the Workers' Party that if you agree with the intent of what we are trying to do with this bill, not just this provision, but the others as well, and the spirit of what we are trying to achieve, and the explanations that we have given in terms of what happened, the nature of these fees, what steps we are taking going forward, I do hope to have your support too for this bill. Thank you, sir.
Mr. Jerogam.
So I thank the Minister for his replies. I understand the difficulty in getting the exact numbers, but is there an order of magnitude that the government can provide as to how many such fees were collected and what's the total quantum? Just an order of magnitude. It doesn't have to be an exact number. And secondly, given the difficulty, is the government prepared to refund these fees, these fees which were illegally collected? And is the government prepared to provide at least a window of time for the claimants to make a claim for these fees which were not correctly collected?
Minister Chee.
Mr. Speaker, I'm sorry, I cannot agree with the way Mr. Giam has characterized the issue with his latest remarks. I've explained earlier that these fees were not illegally or wrongly collected, and they were not inappropriately collected. I've explained why. Services were provided, costs were incurred. We were trying to recover the costs for providing these services. So there isn't a wrong collection that we are required to refund or we should refund. So this is quite different from the previous case that Mr. Andre Loh cited about the GST, where indeed some of the amounts were wrongly collected, and for that one, the government provided the refund. And in cases where indeed that mistake was made and the wrong collection happened, I think that is the correct thing to do, and we have done it, and we will do it. But in this situation, I hope Mr. Giam understands the explanation that I've been, and my colleague SPS Harun had been providing, which is that these were actual services that were provided, fees were collected based on cost recovery, and so it was not a wrong collection. Thank you.
Mr. Fadli Fauzi.
I thank the Minister for the question. I just would like to, again, state my concerns with the issue. Firstly, if these fees go a long way back and they affected a large number of people because, these are very routine things, then would the Minister agree with me that there is a real risk of some kind of administrative oversight? That's one. And I think this is in contrast with the finality of the extinguishing of the claims, because my concern is that there is a real risk of oversight due to the amount of people involved, and we should not have such a finality of the extinguishing of their claims. Rather, we should give them some time, or at least the options of refunds. So that's one part of it. The other part is a question that I raised earlier about how they decided that they had the statutory basis to charge administrative fees. Because going forward, I think this would be useful as a process, as a process issue, because to avoid being in such a similar situation going forward. Thank you.
Minister Chee.
Thank you, Mr. Speaker. I think Mr. Fadli, I had explained to Mr. Fadli and also to other members that the fees were not wrongly or inappropriately collected. So with the issue of administrative oversight, I'm not sure what he meant by that. If what he meant was that we wanted to make it clearer, yes, I agree, and that's why we are here. Because we wanted to make sure that going forward, the situation is clearer, there's less ambiguity. So if that's what Mr. Fadli meant, then yes, we're on the same page, because that's what we are trying to do with this bill. Make the situation clearer for the fees going forward. But we still need to deal with the past collection. And what we are proposing, coming to this House in an open manner, transparent manner, and to explain what the situation is that we want to validate those collections which were done in the past because they were treated as administrative fees. And that's what this bill is about. So I thought we had arrived at a position where there's some level of common understanding when I heard Mr. Singh. So I hope the Workers' Party members could also agree with our explanation. And like what Mr. Singh said, we understand where the Workers' Party is coming from as well. And if we could seek your support for this bill, based on the explanations that we have given, and as I said earlier, we will go back and see to what extent it's possible for us to put together the data that you requested for. We will try our best. We will share this data with you to the best of our ability to put it together so that you have a sense of the quantum, you have a sense of the amount that we're talking about every year. That's something that we will attempt to do. But for now, I seek your support for this bill. Thank you, sir.
Okay, I hope I'm starting to hear the same questions and the same responses. So if there are further clarifications, I will allow it, but let's not repeat the same questions because you'll get the same answers. Mr. Fadli Fauzi.
I think the minister asked me what I meant by administrative oversight. What I mean is human error. Like, in all systems, no system is perfect. So I think it's perfectly understandable if people make mistakes. So if this issue affects a large number of people, there is a larger chance that a mistake would be made. So that is what I mean by administrative oversight.
Minister Chee.
Speaker, I thank Mr. Fadli for his clarification. I think we're talking about two separate things. Today, we are not here to present a case where there was human error because the fees were wrongly computed or wrongly collected. Today, we are here because the nature in which these fees were prescribed, they were treated as administrative. But going forward, we will put them into legislation. And then there's this issue of what to do with the past collections, which we are proposing through this bill for Parliament's agreement to validate. So I think two separate issues, and that's why I said I don't think this is an issue of administrative oversight in the way in which Mr. Fadli had described. Thank you, sir.
Ms. Lim.
Thank you, Speaker. Clarification for Minister. I think it's quite clear we're not denying that services were provided and residents had benefited from the services. And I also would say that we do appreciate that MND did this internal review to uncover this problem, if I can say that. But would the Minister also not agree, really, that it is an important safeguard for citizens that the government acts in accordance with its legal authority. And one of those principles is that if the government is going to collect money like taxes, fees from the citizens, then it has to be properly authorized by Parliament. So the fact of the matter is that those past collections were not authorized. And that's why AGC has said that they should have been prescribed, and that's why we're here today.
Minister Chee.
Thank you, Mr. Speaker. Please allow me to clarify Ms. Lim's point that it depends on how the fees are being classified. Because if they are classified as administrative fees, then the fees can be collected by the agencies. But in this case, because they are considered regulatory, and therefore the advice is that it is more appropriate, it's better if we put it into legislation going forward. So that's what we have done. So I think that's an important point that I need to clarify. It's not that the administrative fees we were unauthorized to collect. That was not the case.
Mr. Singh.
Minister, I don't want to belabor the question. Was the MND advised after the review with the AGC, was it the AGC's position that collections before the first reading of the bill were illegal?
Minister Chee.
Mr. Speaker, my understanding from the review was that AGC felt that rather than leave it as an administrative arrangement, it is better, given the nature of these fees, for us to put it into legislation. So that's what we are doing. But AGC also supported, and that's why we won't be able to present this bill if it's not with the support of the AGC, that we come to Parliament and seek Parliament's approval for the bill to validate the past collection. So that's what we are doing.
Mr. Singh.
Mr. Speaker, that doesn't really answer the question. Was it the AGC's position that the collections hitherto were illegal?
Minister Chee.
I've explained this earlier, Mr. Speaker, that AGC's advice to us was that these fees, because we consider them as administrative, it is better going forward from a legal point of view to put them into the legislation. And that's what we are doing. It is not, so we don't want to leave this loose end unaddressed about the past collection. And the way in which we do address this is to bring the bill before the House in an open manner and to explain to the House this is what happened, this is what we are proposing, and to validate these past collections. Because they were treated as administrative fees in the past, not that they were illegal or inappropriate or wrongly collected, as a few members have used those terms. That's not the case. But for avoidance of doubt and to reduce ambiguity, it is better to bring it before the House and to validate these fees through this bill. So that's the approach that we are taking. And I hope, as I said, to be able to get the support from the whole House in terms of how we deal with this so that we can move forward. But going forward, the fees will be part of the legislation. So we will be in compliance with the advice from AGC arising from the review. Thank you, sir.
Let me put the question to the House now. The question is that the bill be now read a second time. Those who agree, say aye. Aye. Those who disagree, say no. No. Mr. Singh?
Mr. Speaker, obliged if you can record our dissent, please.
Okay. We will have that recorded. Could those who want to have that dissent recorded, please stand? Okay, you miss it. I think the ayes have it. The ayes have it.